Welcome to the Iowa RIA and Iowa Landlord Association, where we educate, advocate, and empower real estate investors.
Hi, I'm Kristin Johnson. I'm the director of the Iowa Civil Rights Commission. Excuse my voice, and I might cough from time to time. You know, it's that time of year. We all get bundled up inside, and we spread our germs around and get sick. So just thought a little bit about my background. My background really is in employment law. So we're going to talk about the housing and the aspect of the Iowa Civil Rights Act today. But I know a little bit about it. Hopefully I can answer questions if there are any. I can talk about, I see that he had me billed as talking about the Senate File 2365. I just wanted to let you know too that a while back my husband was dabbling in tax liens, and we ended up with a house that we rented out. So we have been a housing provider. We have been a landlord for a while. We've sold that property since then. But we've done it in just one property, but that is a lot of work to be a landlord. You know, I know where you're coming from, and if many of you are managing multiple properties, you know, we get it, that it's not easy. So, but we have, you know, laws on the books that we have to enforce. And so one of those laws is the law that requires a housing provider to reasonably accommodate people with disabilities. Why do you think, or does anybody want to take a stab at why that's in the law? Came about with the Americans with Disabilities Act back in 1990, I think, 1991. That's when I was just a baby, or a baby lawyer, actually.
It's not always convenient to accommodate those things.
It's not.
We're probably using it as an excuse to deny applications.
Right. The idea behind the Americans with Disabilities Act and the requirement to reasonably accommodate people who need tenant or who need housing, also in employment, public accommodations too, is to eliminate barriers for people. Barriers for people who need housing, barriers for people who need employment. You have your hand up. Did you have a?
Yeah, I'm a little confused about what we're talking about. ADA covers service animals, but are you trying to talk about companion animals too?
Well, I'm not even talking about animals yet. I'm talking about the principle of why our legislatures and Congress decided that they're going to require housing providers and employers and public accommodations to reasonably accommodate people with disabilities. So to get the idea of, you know, to understand what the public policy behind the requirement in the first place. And the public policy behind the requirement is to eliminate barriers for people with disabilities. So that's where we start from. That's the idea. And it was, you know, a public policy decision that the providers of housing, the employers, had the best ability to bear the expense in some cases. That's where the legislation comes from. So when you're looking at, you know, oh, they're making us spend money, or we're having to do, you know, it's costing us money. Yes, that's true, and it is favoritism for people with disabilities, but that's what the Congress and our legislature decided to do, and that's how we enforce the law. So, Fair Housing Act, we're going to talk about assistance animals. I have a handout. I don't know if you have it. It's just a very short, you know, some of the things, like terminology. One of the things, and this is your point, under the ADA, there are service animals, right? Service animals are trained to perform a function for people with disabilities. However, under the Fair Housing Act, there are assistance animals. Assistance animals do not have to be trained, and they don't have to be dogs either. Under the ADA, it has to be a dog, or in some cases a miniature horse. But under the Fair Housing Act, if it's an assistance animal, it could be a cat, it could be a hamster, it could be a snake. We've had cases involving chickens. We've had cases involving goats. And they don't have to be trained to do anything. So an animal that's trained, a dog that's trained to do maybe for a seeing eye dog, for a blind person, or a dog that is trained to be able to detect if somebody's going to have a seizure or to detect that their blood sugar is getting too low. We see these. That's the service dog situation. When people have a need for an assistance animal, they're called assistive animals in some cases, emotional support animals, but the HUD, under the fair housing laws, they call it assistance animal. And that's the broad category of non-trained animals that are needed for people with disabilities. So it could be, yeah, you have a question? I said, a service dog, a service animal could be a miniature horse.
And you can put that in your apartment?
So a service, by the way, all service dogs would be assistance animals, right? Because they will, even though the definition is different, a service dog or a service animal would be a subset of assistance animals. We can draw a diagram, a Venn diagram, but that gets into the later issue that our commission and our investigators look at, which is the question of undue hardship or reasonableness, right? Is it reasonable if you have a small apartment to allow a person with a miniature horse to live there? But not very many people have miniature horses as service animals. They're big, they're expensive, they're messy, they take a lot of effort. And I've never actually seen one except for on the internet.
We use them for therapy animals, go out and visit a lot.
For therapy animals, okay, but that's not a service animal situation, right? I think the thing about miniature horses is they're strong enough so it's like a better physical support for some people, perhaps. But they don't have the ability like a dog to fetch or open a refrigerator door that I know of. I don't know. So I've never seen one in action. So we have the assistance animals. Now, a lot of you might have no pet policies in your leases. An assistance animal is not a pet. So that is something to remember. If you get a call from somebody who says, hey, I have an assistance animal, will you waive your no pets policy? What's your answer got to be?
Show me your paperwork.
Yes, if, and you can require some confirmation of the need for the assistance animal. But what you should not be saying is, no, we don't waive our pets policy.
So you can ask them if they have a disability. What is your disability? This animal is helping you there?
You can ask 2 questions. It's on my handout too. You can't ask, what is your disability?
What does the animal do?
You can ask, do you have a disability? And then the second question you can ask is, do you have a disability-related need for the assistance animal that allows you to the equal opportunity to use the dwelling? Do you have a disability-related need for the animal that allows you equal opportunity to enjoy the dwelling? Those are the questions that,
What situation would the answer to that question be no?
if they have, if the person's animal is not for their disability, just a pet. So that's where you get into, the doctor is probably going to say, yes, you can get a doctor's note, but we can do a lot more than you can. As the commission, for an investigation, the first thing we look at is, what is their disability? We can ask those questions. Landlords cannot. So we can go in and look, have they been diagnosed? We have questions about, we can ask questions about how does this disability affect your major life activities? And then we can look into more detail as the commission and investigation into whether or not this animal is necessary for their disability. And so we literally see that there are people maybe PTSD or anxiety disorders, who are able, because of their animal, because of their, their dog or their cat, to lower the amount of medication that they have to take for their disability. So, just the presence of their pet at home does have therapeutic effect. And so you can get confirmation that, we can get confirmation from that in detail from the medical providers. Unfortunately, under the law, and this isn't the way that only Iowa interprets it, this is the way HUD does it. This is a federal guidance. They don't, because of restrictions and privacy rules, and they want to avoid the chilling effect of having a landlord know too much about a person's medical history. You're not allowed to ask too much. So you can ask those 2 questions.
How do we escalate it to a commission review versus us asking questions? How does the situation get escalated?
Oh, all right. So this is what happens, and it's a risk. You say no. Then they file a complaint. And then we investigate.
We can't just ask you to investigate before saying.
No, it has to be a complaint filed.
That makes us look bad then. What's our liability then if we say no when we shouldn't have?
Well, then there may be damages. There may be,
Meanwhile, the property is gonna be rented to somebody else by the time you get to
Yeah.
this point. So what do we do about the people that are just trying to get a dog in for a pet?
Right.
Somebody doesn't really need anything. I mean, that's our problem. They're saying they need this, they get a piece of paper saying they need it, but it's just purely a pet.
right.
Not because they have a need.
Mm-hmm.
How do we,
Sort that out.
Well, if you
Yeah.
have multiple applications, you don't have to accept them all. You don't have to.
So
Right,
if you
but
rent
not
it to
everybody
somebody
gets multiple
else,
applications within a couple days, I mean.
well, first of all, 9 times out of 10, if it's somebody, but let me go back this way. Yesterday, for interest, just out of interest, I went on the internet and I found a website, and I answered questions honestly, and I got this email that said, "Congratulations, it appears you qualify for an ESA. Pay $150 and we'll send you a certificate." Didn't ask me for a diagnosis or if I had ever been diagnosed. We know this is out there. 9 times out of 10, if you get somebody who applies for a rent and has one of these and there's no disability and you tell them no, you're done. They're not going to come to us because then they have to prove they have a disability, and that's the first thing we look at. Do you have a disability? And we've only had 1 case where they didn't prove that they had a disability, and we found no probable cause. So 9 times out of 10, if you call their bluff, you're done. But you have to be careful because there are some people who do have a disability and they do have a diagnosis, and they will be able to establish that they have a disability and a need for the animal. So many hands.
Is there any law against them doing that, and what is the consequences if they do?
Currently, there is not a law against them in Iowa
Should
doing
there
that. That's something that perhaps the legislature could look at. And that was part of some of the legislative efforts last term that didn't get passed. Yes.
You're showing paperwork, and the term came up, paperwork. So then the question arises as to the fact you said the doctor. Now, there's others that can give you paperwork, if you will. I'm aware of that. Would you enunciate about that? What are the things we should be looking for that are bona fide?
Okay, so it doesn't have to be a doctor, I think, is
Right.
that your question? It could be a counselor, it could be a psychologist, a
Right.
social worker. I personally, so I'm giving you some of my own opinions, because what HUD says, I personally think goes a little too far. But there again, that's HUD. It's a federal law rules. So even if we try to change state law, you still have to comply with federal law. So, if I was having to deal with laws, I'd rather have the state and federal laws be the same. I wouldn't want to have to deal with two different kinds of laws. And that's how we try to do it. So HUD says that the leader of a support group might even be the person that can provide the note that says they have a disability and or disability-related need for the assistance animal. I think that goes, personally, I think that goes a little too far, but that's what HUD says right now. So, I mean, maybe there's some way nationally that you could make efforts to go to HUD and say, you know, it's too far. You need to bring this out back, and you need to help us deal with these fake internet certificates.
It needs to be a little more definitive.
Yeah.
So
But-
what
No. By the way, forms, the Senate File 2365 says that there's a form that they want to require the provider, no, I'm not going to say doctor, it's easy to say doctor, but provider to provide. There again, HUD says that you can't elevate form over substance. You can't say you have to cross all the T's and dot all the I's, and if you don't, then the landlord gets to say no. And if you think about it, a lot of people with disabilities, they just don't have sometimes the ability. Their disability prevents them from being able to dot all the T's and cross all the I's. Or did I say that? No, switch that. It goes the other way. So you have to look at the spirit.
But they're
What's
not-
that?
The medical provider should be educated enough to fill out the form.
Exactly. And they don't come to us and ask.
Yeah, that would be a topic of discussion. That would be a request for training for medical providers, because that's the biggest issue that we see, is that the medical providers don't understand. And
Right.
so a very common thing that we receive is a note, typed or handwritten from a medical provider that provides a diagnosis, but that doesn't necessarily confirm a disability. So they say, please let so-and-so keep his pet cat, not a system animal, because he has anxiety.
Yes.
So that does not answer any of those questions for me, and people become very frustrated. The medical providers become very frustrated, the potential tenants or existing tenants become very frustrated. So more training to the medical providers as far as what the law says and what they should be looking for when they're requested this would be
Right.
extremely helpful.
That is something that, I just made a note of that because we have to figure out how, we don't get not like the landlord associations that come to us and say, please train us on how to follow the law. The doctors and the medical providers, they don't do that. They don't come to us. But they don't come to us and say, please tell us how to follow this law.
If we're in violation of this law, what are the damages? How are they assessed?
That's an excellent question. So his question is, if a landlord does violate the law, what are the damages? So it depends. It's a case-by-case basis, and it depends on how the law was violated. If you denied housing, perhaps it will be next housing that's available, you need to give it to them, and then whatever out-of-pocket loss that they had because they didn't get the housing, and maybe emotional distress damages. But if you go to our website, we put our settlement agreements on there, and you can see, there's very rarely is it very in the four figures even. Yes.
Yes. So we have a person who's qualified in all the ways that we checked, and then after they move in, if they signed the lease, they moved in. Forgot to tell you, I have an ESA.
That what? I have what?
Emotional support animal.
Well,
ESA.
assistance animal, yeah.
So now where does that put
Well,
us?
so then you can say, oh, well, I need documentation, I need
So
to,
even though they lied on the application, I still
Yeah.
have to accept it.
well, you don't have to accept it until you get
And then a
confirmation.
follow-up question.
Yes.
So no matter what we would ever do in the state of Iowa, none of it's gonna matter because we have to follow HUD housing
Yeah.
requirements first. So all this today is really smoke and mirrors.
I don't know about that.
Well, if none of what we do here elevates itself to a law, and if we pass a law in Iowa,
Oh,
it does not gonna matter because we have to follow HUD.
okay. Well, I'm
True or
hoping
false?
you have to follow HUD.
Okay.
You have to follow the Fair Housing Act, the federal law that applies.
When I read that Fair Housing Act, it only mentioned companion animals briefly. It didn't define the the term or anything.
You are so right.
All the things you're saying now are something that's come up later after Fair Housing Act.
It's not
so-
in the code, it's in the regulations, and it's in the guidance, and it's how they say they're going to enforce it.
So HUD can change those regulations at any time.
Right. They
And so
could
can-
change
and so can
guidance.
Congress.
They have. HUD withdrew a whole bunch of letters recently when the new administration came in. For some reason, they haven't done anything with the assistance animals yet. They haven't done anything to withdraw any of those guidance letters or regulations.
Where would I find those regulations? Because the law doesn't say anything about it. And the law isn't, people have to understand it's not a law in the first place.
It's actually like guidance letters even. Yeah, it's not in the code, it's not in the statute. And it's not even necessarily in the regulations spelled out the way, it's in guidance letters. And those guidance letters can be withdrawn. And like I said, HUD in other aspects, like affirmatively furthering fair housing laws, withdrew some of those guidance letters, but they haven't done it in this case.
So that's all under Ben Carson?
Huh?
That's all under Ben Carson then?
Right,
Okay.
right.
So it's bureaucrats making rules.
Yeah.
So, yeah, they are, if you Google Assistance Animal Fair Housing Act, and you can get to those guidance letters they're on their website. And they're published by other people, republished by others too. Yes?
So we have somebody who says they have an assistance animal. Okay, there's no set form for anybody to fill out. Is there a way that we can come up with some kind of a form that we can ask them to take to their doctors with specific questions? And in that case, what would those questions be?
Those questions would be the ones I gave you. Does so-and-so have a disability? That's number one. Number two, does the person have a disability-related need for the assistance animal that would allow them to have equal opportunity to enjoy their dwelling?
So that's it.
That's it. Yes.
Is there any interpretation of any of this that would mean they could have two assistance animals?
Oh, well, good question, because that does happen. We actually had somebody ask this question once, which I think is funnier, which is somebody said they had an assistance animal and then they needed another animal as emotional support for their assistance animal. Which we would say no, because it has to be the need of the tenant, not the animal of the tenant. So if each of those animals serves some sort of role for a disability, then they might be able to have two. A lot of times here we get two people who live in a place and each of them have their own assistance animal.
You know, every pit bull I've ever met has been an assistance animal.
Well, of course they are. Because it's case-by-case basis. You can't say we won't allow pit bulls. You can't, as a broad category, rule out a certain type of animal. It has to be on a case-by-case basis. Yes.
Sitting here and listening to all the things, all the objections, all the rules and all the regulations, you can't believe how ridiculous this is. If you were a business person, you wouldn't invest 5 cents in what you're talking about. I wouldn't. I happen to know Dave too, and I know that we've had this discussion before, and the government just strangles you with their rules and regulation. I'd rather take my money and give it to the homeless.
Are you allowed to put
And I think it's
time
it's prime time that we, the people, start standing up to all this bureaucracy and so forth, and you're interpreting things to us that we put the money in and then you do the interpreting.
Well,
And-
I just
and-
want to clarify that I'm passing on to you what HUD has done as an
I understand that, but still, I
So the
don't,
question was, can there be a maximum size or limitation, weight
or
limitation?
even a breed specific?
And the answer is you can't have a blanket rule like that. You have to look at each animal on an individualized basis. Because some of them, let's say you have a tiny little place, 1 bedroom or something, and they have a giant Saint Bernard or something. And it's loud and they live upstairs and it's noisy. You can deal with it a different way because the animal has to be under control. That is one requirement. So if you have a person with an assistance animal that's a dog that barks all day while the tenant is away, that's a control issue. So you need to work with the tenant. You can't just say you're out. You need to say, hey, look, your dog is bothering the other tenants. It's interfering with their quiet enjoyment of their of the property. And so you either need to figure out a different, get a different dog, get him to stop barking, and please don't let him put bungee cords. Did you see in the paper today? Awful.
What's that?
And if you don't, then you're going to have to move out. I mean, you can do that, or if the dog is ruining the property.
So they're doing that illegally?
It has to be a case-by-case basis, but sometimes you'll have like a complex with more than one building, and maybe they'll say, well, this one we have to reserve for people, with animal allergies or fear or whatever. We have this building that you can be in. Yes.
Could you limit pythons to under 10 feet?
See, there's a blanket rule again. You can't do a blanket
Yeah, except all
rule.
in any size.
No, you have to look at each case on a case-by-case basis. Where are they gonna live and what is it? Is there an alternative that's less,
You may not be able to make a reasonable accommodation for a 10-foot python in your property, is that correct?
What's that?
You may not be able to make a reasonable accommodation
It may not
for
be
a 10
reasonable.
for a 10-foot python.
Because
right?
maybe there's
Or a
not.
miniature horse.
How do
or-
they, where does a 10-foot python stay?
Yeah.
I mean, do you have a cage that can fit wherever it wants? In the vents of the, yes.
Could you back up just a bit? You said to Google either Assistance Act or something else?
No, Assistance Animal and Fair Housing Act, that's what I would.
So the problem with case-by-case basis is because when a judge makes a decision on that, and I assume you too, they end up making these guidance letters and rules off of that, which is a blanket law.
No, because the rules came first, and the rules are, the main overriding rule is case-by-case basis. That's
And
the
so-
overriding.
So it's a moving target for us.
What's that?
It's a moving target for us because nothing's written in
You
concrete.
have to look at each case on a case basis.
Yeah.
And I put this in bold, and I underlined it, and I put exclamation points. Interactive process. Talk with the tenant. Say, this St. Bernard is too big for your property. Is there something else we can do?
They just want what they want.
That's right, but
They don't care
they have a
about
duty to come back to you and interact with you as
So
well.
a couple other questions. Is, looking forward into legislation that we might be able to get enacted, or maybe we can do on a state level through your department, is there a way we can get a definition of medical provider more restrictive than anybody who has read a medical book or says that they've got a title? Because right now, it's like you said, it's somebody who leads the discussion.
If they would do that federally, yes.
Why does that have to be federally? Because if the
Because
town government doesn't cover it, then we can make a law that
Because the state law cannot be less protective of the tenants.
it can be more restrictive.
I thought we were just have to stick, right?
Second thing, is there any liability that the medical provider has? For example, they move a cat in, which, like this gentleman said, we didn't know it, and then we find the cat, and then they come up with this, doctors don't. Okay, now we gotta allow the cat. Cat dander and everything gets into the carpet and into the floors, the tenant moves out and it's thousands of dollars to correct the situation. Or because we didn't know about it, we re-rent it to somebody else who is assuming that the place is a no-pet policy, and they know they have an allergic reaction to cats, but they don't know that there was one in there before. Now, we get sued. How are we protected? You're not. Okay.
I'm not saying
But-
you're not, I'm saying that's to be determined. And it involves, it would involve a lot of tort law, it would involve foreseeability of damages. This is go way beyond sounds like a law school exam, doesn't it? I used to have classmates. I used to have classmates in law school who ask questions like these, but they're really good questions. and
Medical
they get it.
providers have no liability. If they lie, they say, oh, you want a note? Fine, I'll fill it out.
So the doctor, in the first place, I'm not sure, is it foreseeable for the doctor if they did a false certificate that the landlord relied upon, that a tenant who came in after the fact would have an allergic reaction and damages, because, I mean, you see how it gets more and more remote. So,
So this website you went to and got documentation,
right.
nobody's going after them, and they have no liability.
See, and we don't have the authority to do that, because we operate under we're not a regulatory agency, we're a law enforcement agency. We investigate complaints, we also do testing, but,
So there's no law on those people who are doing that via the internet with that certificate?
they're out of state, so it's outside the states. A lot of them are in Colorado, California,
How
they're not
notice there's
outside
people all over the country?
the scope of Iowa's authority. And they're getting paid, people are paying for them.
Back to these cats, I have a really bad cat allergy.
Right.
So if I have to go into my tenant's apartments and the cats bother me, can I tell them? I mean, I'm just asking, would it be reasonable to say no cats, period? Because if I go in that, what about me? I mean, that's my question. I have no protection.
So it's a really good question, and what we say in that case is that you need to hire somebody else or get somebody else to do that for you. Because, and it all goes back to where I talked about at the beginning, the public policy. When they enacted this law, Congress and the legislature determined that the cost could better be borne by the landlords.
My question was, let's say they tell you they have the need for the assistance down there, run the total background check on them. Let's say they've got judgments against them, their finances are bad, and other things. Do you have to rent to them just because they have?
No, that's a legitimate non-discriminatory reason.
Yeah.
You don't have to.
If you look hard enough.
The same thing with, if the animal is not under control. That's a legitimate non-discriminatory reason. That's because the animal is destroying the apartment. Yes.
So if we're allowed to ask these questions that you've noted in number 9, like to them directly, are we allowed to ask it on our applications? Ask them on our applications?
Well, I wouldn't.
What was the question? No, not a therapy question, but to say. Application.
I wouldn't
have
ask.
a service agreement. No.
Do you have an assistance animal? I wouldn't either. I would do that. Wait until they come.
Put the idea in their head that they'll start doing the research and they'll figure it out.
Okay, so, I know you all have so many questions. I don't know how long we anticipate to go in with the
Typically when
it's a hot button topic.
It is, I know it is.
As an enforcement agency, and you find fraud, and you guys find fraud, what action do you take against that tenant? What do you do against them?
Right.
If they damage their property, destroy their carpet, what do you do against them?
We don't do anything against them because we don't enforce those laws.
Yeah.
But if they file a complaint with us, we dismiss it.
Oh, wow.
If, not with the damage, but if they come to us and say, well, they didn't allow me to have I told them I had an assistance animal. Our first question to them is, what's your disability? We can ask these questions. Do you have a disability? What is your disability? Give us your medical documentation. I want to see your diagnosis. Our investigators can do that. And if they didn't have a disability, we're done. That's the first thing we look at.
So the tenant has everything to gain and nothing to
All that stuff
lose.
that they provided you was fraud.
She doesn't care.
Yeah,
It's not that I don't care, it's that it's outside the scope of our authority.
The Civil Rights Commission does discrimination, ADA, things like that. There's the Attorney General's office might care if it's fraud or someone. I understand, but there's other regulatory bodies.
Small claims, I mean, you go to court.
You go to court.
Blood from a turnip.
Yeah, exactly, right. Well, we couldn't get it from them either, by the way. But our authority is limited to protecting people from discrimination. That's what it is. If they make a false claim, all we can do is dismiss it.
Why should we prosecute it?
What's that?
Why should we prosecute it on the animals moving in afterwards? So you filled out all of your lease and all of your stuff, isn't it a breach of the contract if they didn't?
No, well, what if they develop a disability during the lease period? You know, we can't just say because it wasn't upfront and I know this happens a lot. My kids lived in Iowa City. They lived in a building that had like 8 dogs. It was a no-pet building. And I can guarantee you, they were, certificates from the internet. And they were kind of mean to my kids, because one of them would play ball in the hall, and my son, built out the door, and then they put a note on his door that, call them names and stuff. And
So
I
when the
said,
dog-
if it happens anymore, call the landlord.
When the dog mauls your kid, or your grandkid, who's got the liability? The landlord. I didn't catch what you said.
I don't know.
What'd you say?
But who's going to be liable? The landlord.
Why is the landlord liable?
If they get a fake certificate off the internet, and the landlord lets them move in, and that dog mauls the neighbor, who's responsible? They go after the landlord.
They go after the landlord because the landlord has the money, but the landlord goes after them,
The neighbor.
Goes after a penniless tenant?
The neighbor should go after the tenant because they're the ones that cause them.
Yeah, so this is outside the scope of what my agency does, but you have your landlord-tenant lawyer here who can explain to you.
Sure.
Loud enough to hear.
In that instance that he just said, I highly doubt that the landlord is gonna be liable. He's doing what he has to do, he's got legal reason to do what he did.
And so it
To
defends.
have that animal there, he has to
Yeah,
have justifiable defense.
you'd have a legitimate.
He was in San Francisco.
You'd have a legitimate defense.
Okay. We're beyond our time, I don't know why we're not getting stopped. All right.
Let's keep it going, let's keep it rolling.
These animals' names.
Feels like she's being attacked.
So insurance,
Like it, coils itself around and
Well,
kills the neighbor.
see, that one I'm not sure of. That is, I'm at a disadvantage. You can't require a pet deposit.
No, you can't do
You
that.
can't get fees. I'm not sure about insurance. I'm not sure. That's a really good question that I would need to ask the supervisor. See a hand up by the window. Hand up by the window, ma'am. You're just.
I know, I want to know if you have a resident that's been in your building, and somebody moves in with their animal, and I know you went over barking, but if they've got allergies, if that dog is bothering you, talk to them, said wash your animal, clean it, and it's bothering other residents, do you have the right then to follow your give them a notice, work with them, and then after that, if there's more complaints, do you have the right to say, I'm sorry, but I've done everything, you've done everything?
Yes, but I've seen case law on that, and it's hard to prove that, you have to be able to prove that the animal is the cause for those allergic reactions.
So she can go to the doctor and say, I've been getting
So
more.
you have to prove that it's leaving the apartment unit, that somehow there's enough exposure to cause that allergic reaction. Yes.
Talk more about testing, testers, what they can do, what they can't do, what they look for.
Testers, okay, sure. So, I just want to start up front by saying, I was a landlord, and I had somebody give me a call. I would rather have a citation from a complaint on a testing call than a complaint from a real person who was denied an assistance animal. Because when we do a complaint based on a testing call, there's no money damages. There's no money involved. All we want is training, and that you promise that you'll follow the law.
Billboard?
Sorry?
Billboard?
Post.
Billboard?
Oh, we don't require that.
Well, you don't.
We don't. I think some other agencies might, but we don't. So we have an employee who, we have a tester, we also use volunteers. And they make a phone call, and they'll tell you, I have a disability, I have an assistance animal, I saw that you have a no pets policy, will you waive your no pets policy? And if you say yes, they might ask you a few more questions, and then they'll be done with the phone call.
Do they let you know?
If you say no, then that's where there might be some more exploration. There might be, just to make sure. And those calls are recorded. Okay? So the other thing that might ask though, yes, I'll waive the pet policy. Will you require a pet deposit? And the answer there should be no. And if you say yes, then they'll explore and they'll solidify it. And then, you may get a complaint from us.
So you can tell them.
You can say that, sure.
Say
But
what?
then when all the applications come in, that's the one I don't pick. I mean, what's stopping that? I mean, if I have
Well, which is why they don't tell you up front.
Yeah, but if I haven't, but I, no, and I don't do that necessarily, I haven't really had much call for it, but.
Well, the testing call, we don't have any
No,
live
it's
testing.
not the call, I'm saying for the tenants, I mean, if I have 10 renters and I feel that, the couple that have no children and no pets are more appropriate for my building, then, I mean, that's not.
That could be discrimination.
Yeah, there should have to be more qualified.
Because you can't discriminate against somebody based on lack of children or having children either.
Only money.
But I'm not saying it.
Right, and so then they might think
Maybe the
so.
background check was better, or,
Sure, if you have a legitimate non-discriminatory reason, that's fine. But if otherwise you have a pattern, the only way to work with without children,
You like that?
you get trouble. You get fined.
I have another question. This has nothing to do with your field though, but the Environmental Protection Agency.
No, I know nothing about that.
I know you, and I agree with it. However, my wife and I moved a house off the Drake campus down into Sherman Hill. And Drake hired a moving contractor to move the houses and to raise them up and fill in, get rid of the houses. So they was going to build a new campus over there. And so we stepped in and we got the house from Drake for $1. And we moved it from Drake campus over to Sherman Hill. And everything was done prior to the time we moved it. So we hired Billy Bell, who was from Madrid, to move it. And he lifted it up off his truck and he did all the work filling in the hole and everything, And so after we got it moved, I got a call from the Environmental Protection Agency. And they said, you polluted the ground over there. And I said, what? Yep, the ground has been polluted and we're going to hold you responsible. I said, well, how can you hold me responsible? Drake University is the one that hired Billy Bell to do all this work, and the only thing we did is he was supposed to clean it all up. He was supposed to just pick it up, and move it over to, and they finally came back and said, well, we won't hold you responsible, but we're going to keep you on file. Is that what you do? That's what I was going to ask you. If somebody has a complaint and they turn somebody in for a particular reason, you keep that on file?
You keep a landlord on file that's had a
Yeah, you keep the landlord on file?
We
for
have,
the
we
complaint?
have a database of all the complaints filed against, and even when there's no cause, we have a database that we keep track of. I mean, it's in our database. What, our database is goes back to before 2000, but we only keep the actual files for 5 years.
Would that then bias the person evaluating if, say, some landlord had multiple?
No, it doesn't.
No? Okay.
No, if it's not founded, it's not founded.
Okay.
Yes.
Yeah, we did have a person in our landlord group in Marshalltown that actually had happened to, with your question about, what was your question again?
People calling?
People call, so he failed.
Oh, the testing.
Yeah, he failed the test call.
Right.
Because he had an ad placed, actually it was an ad call. So he had an ad placed that said, ideal for young family with child.
Oh, I
Okay.
think that came from us.
No, it did. Because then he had to go through like a 1 or 2 hour seminar with somebody on the phone. And I will give your department kudos. That was a great learning experience. I actually sat in on it. No, I was not the person.
See, discriminatory advertising is prohibited, just blanket prohibited.
Yeah, I understand. But when I was when we were on the phone on the teleconference together, I asked this party, somebody in your department, they may or may not be there right now, I don't know, this question. So some of our units we rent, all in. In other words, $395 rent, $100 for Alliant Energy, $50 for City of Grinnell services. One check, no deposits, well, a deposit for their rent. Then I asked the person, I'm going to ask you now too, what happens if we have, some people call these folks couch crashers. So it's leased to one person, but just mysteriously people fall out of the air, and now there's 3 people in the apartment. Right through the chimney. Just amazing how they get there. No accident, no injuries.
So now there's
and the
more
person
than
in your department said, I can't change the rent, but I would have a good cause for changing my utility structure. What's your feelings on that?
So
Meaning charging more for utilities, because we got 3 times more toilet flushing.
Right.
3 times more shower use, if they take a shower. 3 times for everything.
Well, that's where the truth.
So what's your commentary on that?
I think it depends on what the lease says, frankly.
I think if you wanted to get them out, you could probably get them out.
If the lease says,
No, I understand that, but you know how long that can take?
Yeah.
well,
You know, all of our problems would be solved in this industry, and I've told this to other parties in the past, if we would define non-paid rent as theft. You'd solve 99% of the problems.
well, so those are, again, beyond the, really the scope of what we do is, because a lot of, I'm just gonna tell you, we get a lot of people who file complaints with us that we don't even open, because it's just a landlord-tenant issue, it's not discrimination. They wouldn't fix my sink.
Yeah, right.
And then they try to tie it to, they wouldn't fix my sink because of my race or my sex or because I'm disabled, you know, my national origin. And if they throw that in there, we have to, because we have to look comparatively. Do you refuse to fix, are you just a bad landlord to everybody? I mean, you know, equal opportunity, bad landlord.
So if they're not cleaning up your dog or horse, what do you do?
That's, again, go to them and you say, this is a violation of the rules of this property. You need to clean it up and give them a warning and do what you would do for any other lease violation.
Now, can you have something in your lease that you add in if they have an assistance animal? You will clean up, you will keep your apartment clean, you will not allow your animal to aggravate other
Can't
residents.
do a special lease provision that only is applied to people with disabilities. That's treating them differently.
Just a standard pet agreement.
But in your general rules,
Like, you won't have babies.
As long as you have it on everybody.
your general rules and regulations that apply to all your tenants.
Everyone, right.
So,
Can you request the vet, that they take them to the vet and you give copies of the vets, you know, the shots are up to date and all of that?
You know, that's something that I'm not sure about. I don't know why you wouldn't be able to as long as you apply that rule equally across the board.
If you have a no fence policy, how can you be equal?
Well, that's.
So if they're damaging the property with their pets, and can you evict them?
With their assistance.
Yeah, with their assistant.
So, yes, as long as you go through the process, warnings, you know, I would warn them, I would tell them, you need to stop doing this and you need to fix it, or if it happens, I'm gonna check it again, you know, whatever you have to do.
Is that called?
With landlord tenant laws.
There's non-compliance.
It's just like, it's just like if
Does that case come back to you, and do you hear it?
if they complain.
But we see a legitimate, non-discriminatory reason is damaging. The animal has to be under control. Yeah, you waved at me, is that because you were saying?
Oh, yeah, I wanted to say hi, and also, what if the tenant gets better, and now it doesn't need the service animal anymore, now it just becomes a pet?
And there's not a regular
That's another part of what
process
it should
that,
be.
you know, to say, we gotta do it again, or you have to re-register or whatever. There isn't a process like that. So I know it's frustrating. It's frustrating. The law is the way it is. It's very broad. I was trying to explain to the reason for it being so broad.
we don't, as an agency, we follow what the law is. We try not to, we push to settle, by the way, before we get to investigation. We do that because everybody should be able to live better with a settlement. It's faster, it's done quicker, it's less expensive.
So you can negotiate a settlement then between the complainant and the
If the complainant files a complaint, the first thing that we do, once we've notified the respondent of the complaint, is we have a conciliator who calls everybody up and says, hey, you know, we're thinking about maybe there's a way to settle this case.
It's always financialized and,
It can be or not. Sometimes it isn't. Sometimes there's no money. It's just they just want training and put a poster up and.
okay, right, okay.
I've got
Yeah.
a sickness
So,
and they've all had it except.
And then there's follow-up, you know, to show us that you did the training. And we do the training and we cost less than.
No, yeah, sure.
Anxiety.
Okay.
Yeah, that's right.
And we're not doing this
I didn't want
to
to get
drum up
more
business.
air.
This is
So
totally busy.
So we proactively did the training then,
We tried.
And
we
I had a
tried. That's why I
complaint.
come to places like this.
let's say I'm fully trained and then I receive a complaint,
Yeah.
then when we get to
Well,
that
if you
stage
settle,
where
you
we're
say,
trying to.
right, I mean, that's, you know, that's your, what you have to,
But then your
Restoration.
person who's trying to settle the complaint then will see that I've had the proper training.
Give me a call.
And then the issue, if that's all they're requesting, then the issue is dismissed.
It just depends on what you think as a settlement. Each one's different.
Each complainant is different in what they
Right.
want as a settlement.
Right.
But if they don't want money, and we have the proper training already,
That's just what you have to work out with a conciliator. I can't tell you that there's a way.
I guess I'm asking you a hypothetical.
Yeah.
So, okay.
There's so many hypotheticals. It's just really hard to you know, give an answer for every situation.
Sure.
What if you try to push legislation through that would say only a licensed medical professional can issue these certificates?
If you did it federally.
Yeah, what I'm saying though is that the federal law would preempt that. That's what you're saying.
Yes. Yeah.
So I guess my question is with regard to this bill that was in front of the Iowa
Right.
legislature. Is it dead or is it still active? And obviously, there's clearly, I mean, it sort of seems redundant or silly because it's gonna be superseded. Is there any way to just do away with it?
So it didn't pass the last legislative session. In my understanding, I think that it's a brand new session, so all old legislation is out.
So they would have to reintroduce it?
I think so.
and put it into- Okay.
Yeah. I think so. I think GA, whatever the next one is, starts up the new one after the election. So, you know, it makes sense timing wise too. So legislation that was, it passed the Senate, didn't pass the House last year.
So I saw something in there that said that if, obviously there's already the federal regulation in place, but that said that if a landlord falsely denied, that they could be charged with a simple misdemeanor.
That was not in the final version.
Okay. I just wanted to make sure that was still not on the table.
That was not in the final version.
And what about certificates from out of state? Was that in?
Not in there. Not in there. And yeah, that's something that is public policy, HUD's not gonna give up on. They're not gonna give up on students. Students come from out of state to go to school here. And there are students that have PTSD, you know, they've had rough childhoods or something happened to them, some kind of medical thing. And for them to have to go to the doctor in Iowa, you know, where their school is, to get an in-state doctor, then HUD's not gonna agree with that. So, I'm trying to be done. No, I know, you know what, and I really enjoy talking to everybody, and I really enjoy answering your questions, and I totally understand the frustration. We do what we can. It's just, you know, it's just one of those things that's out there, and you just need to deal with it. And if you want to, you know, anytime you can call me, call Linda Brathwell. She is our supervisor. A lot of times if you give her a real scenario, she's not going to give you an answer because down the road we might see it as a complaint, and we can't tell you in advance because we're neutral.
So if we call it a hypothetical then?
And if you try to call it hypothetical, somebody might call your bluff.
Andrew's not here, so I have
Mr. President, I will take the opportunity to adjourn the meeting. Thank you all for coming.
So you have the opportunity.
So that's where, yeah, so that's where I was saying.
Thanks for watching. We hope this production empowered your business. Please like, comment, and subscribe for more great content. And don't forget to join us in person for powerful networking and priceless information at our next live event. For all event information, please go to our website,